Hi, I'm Debbie Moraes, and once again this is Legal Matters, the program that has been designed to address some of the timely, critical, and sometimes contentious issues that face consumers and businesses today. We say legal information, it's practical information, and straight talk about a wide variety of topics that affect your home and your work life. Today it'll be about technology, the internet, intellectual property. Whether you own a business or you work daily with technology or even minimally use it, and who doesn't, there are many hot topics that can get you into a lot of hot water. We're hoping today to address some of those topics for you and see if they can help you a little bit. So, what's considered intellectual property, and even if you clipped a piece of clip art from the internet, could you be in trouble? Well, we have some experts here who are going to address it from both the legal and the technological standpoint. Today we have with us a special guest, so we'd like to first introduce her, Pam Viveros. Welcome. Pam is a vice president from ThinkTech Computers, an IT consulting and network service company located in New Bedford, and it serves Rhode Island and Massachusetts clients. She's also host of Tech Angel, which is a WSAR radio show that she's been working on, and she's also co-author of a book called Hassle-Free Computer Support. Welcome. And once again, we have with us Jackie Grasso and David Bizarre from Odette Bizarre Cordero Grasso law firm in East Providence. So, it's a whole new world. I guess it's a wild frontier and a new frontier. There's so much that is new every day. It's hard to keep up, but let's start with the broad brush strokes of intellectual property, and that's a law in itself, never mind what happens with technology. Lawyers first, okay. Briefly, what's intellectual property?
So when you say intellectual property, you're usually talking about trademarks or copyright, that type of thing. Federal government has an office, it's actually in the Constitution, the Patent Office, about registering patents, trademarking names, things of that nature. So on the internet, if we're going technology, there's companies that own images that you can't put on the internet without their permission, such as I think Getty Images is a big one. Mm-hmm. Is that right, Pam?
Yeah, that's correct, yeah.
Right. So they would have the right to use those images, and you would pay them to be able to use that image on your website or wherever you might want to use it.
And typically those images, you'll find they actually will say the company that owns them across them, or it will say copyrighted when you go to use them on those particular
Correct.
sites. Yeah.
And apparently that would be very nice if it were just that straightforward. It seems as though it's become a little more complicated than just, yes, you can clip if you agree to these terms. And some of those terms, I'm wondering how many people actually ever, A, read them, and B, if they don't, do they get in trouble? So, for example, someone took a piece of clip art from Microsoft, yeah, and they decided to integrate it into something that is their own. There's some problem about how they integrate it and how they make a derivative of it. Who gets into trouble about that? What do you do about that? What do you as a technology person suggest to someone who's thinking about incorporating that in their site, even if you don't do their site?
Yeah, I mean, really from our perspective, we would obviously refer them to an attorney and make sure that they are, from a legal perspective, handling it that way. I mean, our recommendation is simply to say you may be at risk here, and that they have to find out more information. So if we're putting together a website or they're asking us to do something like that, from our perspective, we would never recommend anything or put anything on a site that we knew for sure, was not owned by them or wasn't purchased by them in terms of images. But other than that, the line is a little gray, so we would have to, defer to someone.
Because when you stop and think about it, if you have a Microsoft program, part of the program includes clip art.
Right.
So isn't there an assumption that you have the authority to use it? And how far can you go with that?
And the internet itself is such a sort of, a Bermuda Triangle in a lot of ways, yeah, right? So you put it out there and then it's out there. And it's really, really difficult to have something taken down. Obviously, an outfit like Microsoft, if it's something that's invasive to them, they're going to find it and they'll certainly let you know about it to take it down.
And the reason I mentioned Getty Images is I find a lot of times I have clients who have gotten letters from Getty Image that we saw this picture on your website and it's ours and you can use it, here's the bill.
Right.
Pay us.
Yeah.
Mm-hmm. Well, Getty, Corbis, there are several of them that are royalty-free. You pay once, you can do whatever you need to with it. But then there are those that have the nuances, as I said, that mean you have to take it, but take it in whole, not do something with it to substantially alter it which is, I guess, an infringement on a copyright, even though you might have paid for the image or paid for use of the image or paid for the license to use that image or whatever. That gets to be a pretty sticky wicket. Have you been finding that people are either asking first or then having to defend it later that they didn't do something that was illegal?
Because I think it's such a complex issue, the patent lawyers aren't around like usual day-to-day attorneys. So I think what they're doing is they're taking the chance and then they're worrying about the consequences later.
Yeah, or they just don't know.
Oh, they don't.
they
Yeah,
use
because
it.
it's so difficult to understand. Like you said, who's reading all that fine print when it says, do you agree with this end license agreement?
Yeah, most people sort of just scroll down, right? They don't
And
even
then
read it. They just go
click next.
accept
Yeah.
Right.
and do the next.
Yeah, that's
If you
true.
have to scroll down to get to the accept, otherwise it's right to the accept for a lot of people.
Exactly.
Yeah.
When it comes to even copywriting, taking information and taking it as your own, I think apart from images, what an interesting abyss that's become. For example, what ends up being fair use? Can you explain what that is? Because I think that's a good springboard from how do you determine what it is and how you might be able to use it.
Well, do you deal with that, Pam?
The only thing I was going to say in terms of copywriting is there is software available now that will actually scan various sites to see if there's duplicate content. And then also Google themselves, I think in an effort to be fair,
Right.
in their search engine optimization will say, okay, well if this copy appears in multiple locations, then clearly it's not actually yours. And so they sort of slap your hand and don't put you on page 1 in Google searches. But from a technology perspective, that's what I was going to say.
Right, and from a legal perspective, fair use, if there's some information that is out in the public domain that you can use without infringing on somebody else's rights, you can put that in. A lot of times you have to attribute it if it's something that you're taking from someone, but generally that's the
So
rules.
for instance, if you're looking at an article on the internet and it says send this link by email, as long as it's identifiable to the individual source, and we're not trying to use it under our name,
Right.
correct? So you're fine there.
Are you? That's the next question I was going to ask, because since links between pages are essentially the raison d'etre for so many websites on the World Wide Web, how do you get to link and not ask permission first? There are so many aggregators, number one, who collect from here to here to here to here. How would you even know at times who was the original source to give attribution to on the one hand, and how do you know whether or not you are causing some problem by just linking without asking permission? If it's out in the public domain because it's on so many sites, does that mean it's fair game, fair use?
I think so, and I think so for this reason. The lot of things that are put out on the internet are now published, and once you put it out there, you retain some property rights in it, but as far as access to it, that's what happens on the internet. So you go in knowing that.
And it's there for everybody to see.
Right.
And yet, was it a couple of years ago, I think, that Google got into trouble with one of the France-based news services, and there was an issue about whether or not they were allowed to just take information and have Google News use it as its own. And I think there was some sort of payoff,
Well,
but
that's
without
different. That we're talking about being able to click from one site to another
Right.
and go to the original site. Google can't take somebody else's work and portray it as theirs and allow you to use it from their site.
But the aggregation process, they do take from here, 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 and then say, dear Google user, do you want to know what's hot on Google News? Click Google News, and suddenly there comes all of the daily news, none of which did Google necessarily hire a reporter to collect, write, interview, etc. But that aggregation issue is an aggravation issue, I think, with many. And how do you deal with that right now? I mean, are you thinking that with the clients that you may have, businesses, perhaps from your perspective, if they're collecting information from various standpoints, are they ever going to be taken to task and have somebody say, this is a cease and desist, or we're having a legal battle over what you can and can't use?
I think if they're trying to attribute it to themselves as the author, then you're going to have an issue with that.
Right.
As long as you have an identifier there that it was taken from somewhere else, like the old college rule, you can't plagiarize. So if you're going to use another author, you need to cite that author. Okay. and extend it over to the internet.
I agree. I think that if our customers, our clients, our companies that we represent are taking somebody else's work and now using it as their own, they could face a lawsuit for that.
Oh, definitely.
But if they are, you want to use the word aggregating, getting information, putting it together, but telling you where it comes from in a blog or something like that, I don't think that there's any risk of liability to them, as long as it's either a click-through or an attribution that's given.
Yeah, and it would be really difficult. You talked about sort of tracing back, kind of how do you find the origin, and it would be really difficult to do. Just like in college, when you're writing a paper, you pull from a bunch of different sources and, you know, paraphrasing a bunch of different things. It's sort of difficult unless you're plagiarizing,
Right.
and that is very easy to find.
Which they actually have software nowadays.
They
I was
do.
going to say, yeah,
Software
right.
so they can see if
A
there's...
professor can run 2 papers at the same time.
That's
and
right. Yeah.
Yes, exactly.
And I guess Copyscape does that too, some sort of checking. Now, if you're working with small businesses and say on the proactive side, they're in the process of creating something and it's theirs, you're challenged with how to protect it from a data standpoint.
So I guess there's really two things of protection. One of the biggest topics in terms of internet, I think, is really social media. And one of the bigger liabilities that I think a lot of companies have is your employees are using things like Facebook and, you know, LinkedIn, and they're free to sort of comment to their friends and family about whatever they want to. And so they could very easily comment about your company and about things that are happening in your company. So I think there's more, for the small business, I think there's more of an issue with that piece of online and what's happening in terms of data going back and forth.
And for the small business person who created something and wants to have it protected, and you would deal with patents or trademarks or whatever it is, how do you deal with the fact that the internet, speed of sound or whatever that it is, how do you keep a small company having the ability to commercialize something at a much slower pace than someone who has a very large company, much faster access to get things into the pipeline? What happens then? Do you, from a technological standpoint, have the ability to protect someone until they're ready to go commercial with it?
I think that it's more a matter of, because to get something on the internet is seconds. I mean, literally, absolutely seconds. So I think it is much more like what Jackie was saying, as far as, you know, it's kind of like, you know, ask for permission after. Right? You know, it's easier to get seek forgiveness than ask for permission. I think that most companies are handling it that way. You know, our responsibility as a technology provider is really just to say, here's what your risks might be, and then it's kind of the onus is sort of on the business owner to make sure they're consulting with somebody, because we can't possibly address those issues. And what are the odds that someone is going to, you know, come after a company unless they're blatantly using information, you know?
Right. Yeah, I don't see that as a bigger risk if it's not actually impinging upon somebody else's proprietary rights. You create a website and you put up Coca-Cola and say that you are Coca-Cola, Coca-Cola is going to sue you and make you take it down.
No doubt.
But if you're selling Coca-Cola products, like an eBay might do, you can do that. And so you can put up probably the Coca-Cola image to show that that's something that you're selling, as long as you have the right to sell it. But I think I'll copyright a new term. I'm going to call it the speed of click, because that's how fast things go out over the internet.
So I think you should err on the side of caution. If you think you have something that may be protected or used by someone else, intellectual property, just do a search with the trademark, the copyright. Trademark, patent office.
And you can use the internet to do that.
Yeah,
Absolutely.
And apparently there's some issue because of this speed of the click that someone may or may not have had an occasion to file first versus use it first. I don't know the difference in that exact law, because I think it's probably a moving scale as it is right now, but an innovator, a creator, may have a great deal of difficulty between the time he or she forms a patent, starts to use it, gets that clearance, and if they haven't filed in the right time and someone else happens to see it, or through the Facebook that they were speaking about it, someone else grabs it, and there's no way to protect it. This is on the other side of it. How about me, as if I'm a creator and an innovator, I want protection for my project that's going to be commercialized before someone else vampires it and
So
can
the first
send
thing
out faster.
you do is you see a patent attorney, which is a very special